Listen up. Welcome to this explainer on company law and the Insolvency and Bankruptcy Code of 2016. I need your absolute, undivided focus right now. We are not just casually reading through laws today. We are literally dissecting the anatomy of corporate existence. From the exact second a company takes its very first breath, all the way to the day it's ruthlessly liquidated, you have to understand the rules of the game. So sit up straight, lock in, and let's dive right into this. Here is the corporate life cycle we are mastering today. 1. Birth of corporate personality. 2. Promoters, MOA, and AOA. 3. Raising capital and shares. 4. Directors and governance. And 5. Insolvency and winding up. Memorizing this exact chronological flow is non-negotiable. You see, you simply cannot understand corporate death if you don't first understand its birth. So, let's start at the beginning. Phase 1, the birth of corporate personality. Pay very close attention here, because this is the exact moment a legal fiction is born into the real world. The fundamental concept you need to grasp is separate legal entity. Drill this English term into your minds right now. A company is not its owner. It's like a completely different person. It can own property, it can sign contracts, and it can sue or be sued entirely in its own name. I am telling you with absolute authority, even if it's just a one-person company, that legal entity stands completely independent from its human founder. And nothing illustrates this bedrock of company law better than the legendary 1897 case of Salomon versus Salomon. Let's break down the legalities here. The facts: Mr. Salomon formed a company, essentially selling his own successful shoe business to a company where he held almost all the shares. But when the company failed, the creditors came after Salomon's personal assets. The rule? Well, the House of Lords delivered a ruling that absolutely shook the commercial world. They said, no, the company is a distinct legal person. The conclusion here is crystal clear. A separate legal entity is established the moment of incorporation, completely protecting the founder's personal wealth. But mark my words, this protection is a privilege. It is not a shield for fraudsters. That brings us to lifting the corporate veil. If you think you can use this separate legal entity as a cloak for fraud, as a sham, or just to evade your legal obligations, the courts will ruthlessly pierce that veil. They will look right through the company, find you, and hold you personally liable. No exceptions. Just to show you how strict the courts are about this, listen to the facts of Guilford Motor Co. versus Horn from 1933. Mr. Horn was an ex-employee who signed a contract explicitly saying he wouldn't steal his former employer's customers. To cheat the system, what does he do? He forms a brand new company and has the company steal the customers instead. Clever, right? Well, the rule applied was that the corporate veil will be lifted if the company is merely a cloak for fraud. The conclusion? The court completely dismantled Horn's fraudulent facade. They slapped an injunction on both Horn, personally, and his sham company. The lesson is simple. Do not play games with the corporate veil. All right. Moving sharply to Phase 2. We've seen the birth. Now we look at the constitutional documents that actually breathe life into the company. The promoters, the Memorandum of Association, and the Articles of Association. The absolute limit of a company's power is governed by the doctrine of ultra vires. I want you to write this down in your brains. The Memorandum of Association, or MOA, has an objects clause that defines exactly what business the company is legally allowed to do. Any act beyond this clause is ultra vires, literally meaning beyond its powers. Understand this clearly. An ultra vires act is entirely, completely, legally dead. It's void. Not even a unanimous vote by the shareholders can ratify it later. Let's vigorously break down Ashbury Railway Carriage versus Richer from 1875. The facts are fascinating. A company whose MOA strictly said, "We make railway carriages," decided to sign a massive contract to actually finance a railway line in Belgium. The issue: can they legally do that? The rule? The House of Lords said absolutely not. Acts ultra vires the MOA are void. The conclusion was brutal for the contractors. That contract was completely unenforceable against the company. It doesn't matter if every single shareholder agreed to it. A company cannot do what it simply does not have the legal power to do. But wait, what about the innocent outsiders dealing with the company? Enter the 1856 case of Royal British Bank versus Turkand. The facts? The directors borrowed money, but their internal Articles of Association actually required a member resolution first, which they completely ignored. The rule? The court created the doctrine of indoor management. The conclusion was that outsiders dealing in good faith are fully entitled to assume that the internal proceedings of the company have been properly followed. This doctrine is absolutely crucial. It acts as a shield for honest outsiders, contrasting heavily with those strict internal rules of the AOA. Phase 3. Raising capital and shares. Your legal entity is born, its rules are locked in, but how does it actually get the cash to operate? You absolutely must memorize this hierarchy of risk and reward. Equity shares versus preference shares. Equity shareholders, they are the true residual owners. They get full voting rights, but listen to me, they eat last. They only ever get dividends after the preference shareholders are paid out. Preference shares, on the other hand, give you a preferential right to a fixed dividend and priority return of your capital if the company dies. But you trade away your voting power. It's a classic trade-off. High risk, high control versus low risk, low control. Now, if you don't want to give away ownership at all, you take on debt through debentures. You need to understand this stark difference clearly. Secured debentures are backed by a charge, meaning you have a legal grip on a specific asset of the company. Unsecured debentures have zero charge. They are just a naked promise to pay you back. Let me make it very clear why a secured debenture holder sleeps so much better at night. If the company collapses, the secured holder just takes the asset. The unsecured holder? They just get in a very long line, praying there are few crumbs left over. Pivoting now to Phase 4, Directors, Meetings, and Governance. As the famous legal maxim goes, a company has no soul to be damned and no body to be kicked. It literally has no hands and no brain. It needs human agents to wield power over its assets. And those directors are not just regular employees. They are fiduciaries, bound strictly by Section 166 of the Companies Act. The severity of these statutory duties is absolute. They must act in good faith. They must exercise reasonable care and independent judgment. They must absolutely avoid conflicts of interest and seek zero undue gain. And today's modern governance demands strict oversight, which is why we now have mandatory independent directors and women directors from major companies to ensure these duties are actually being followed. But what happens when these directors inevitably misbehave? You need to understand the incredibly harsh reality established back in 1843 by Foss versus Harbottle. The facts. Minority shareholders tried to sue the directors for fraudulent conduct. The issue was, who actually has the legal right to sue here? The rule laid down was the proper plaintiff rule and majority rule. The conclusion was completely devastating for the individuals. Only the company itself, guided by the majority vote, can sue for wrongs done to it. Individual shareholders were literally thrown out of court. Why? Think about it. Because if every single minority shareholder could sue the management anytime they wanted, the company would be completely paralyzed by lawsuits. So what does the minority do? Do they just suffer in silence? Absolutely not. Under Section 241, Prevention of Oppression and Mismanagement, we find the ultimate lifeline for minority shareholders. If the affairs of the company are being conducted in a manner that is oppressive to any member or prejudicial to the public interest, you don't need the majority's permission anymore. You bypass them and go straight to the National Company Law Tribunal, the NCLT. This is the absolutely necessary, powerful exception to the ruthless majority rule of Foss versus Harbottle. And now we have reached the final, somber stage of the corporate life cycle. When the capital finally dries up and the governance totally fails, we face corporate death. Phase 5, Insolvency and Winding Up. I introduce the Insolvency and Bankruptcy Code of 2016 to you with immense respect. This single piece of legislation changed the entire Indian economy. The Corporate Insolvency Resolution Process, or CIRP, is a strict, unyielding 330-day timeline. The moment a company defaults, the promoters are immediately thrown right out of the driver's seat. Absolute control is shifted directly to the financial lenders, known as the Committee of Creditors, or COC. The primary goal is to revive the debtor, for sure, but that 330-day clock is ticking loudly. And who holds the ultimate power in this situation? The Supreme Court delivered its ruling in the landmark 2020 case of SR Steel with absolute finality. The facts: the Koch approved a resolution plan that paid the financial creditors really well but treated the operational creditors extremely poorly. The rule: the Supreme Court hammered home that the Committee of Creditors has absolute commercial primacy. The conclusion: the NCLT's role is strictly supervisory. The courts cannot and they will not second-guess the commercial wisdom of the financial creditors. The Koch is the supreme commander of the resolution plan, period. Now, if that 330-day process fails, the company is liquidated. And when the assets are finally sold off, we follow the Section 53 waterfall mechanism. Let's walk through this logically from top to bottom. Who eats first? Number 1, the cost of the CIRP process itself. You gotta pay the liquidator. Number 2, secured creditors and workmen. Number 3, unsecured creditors. Number 4, the government takes its taxes. And at the very, very bottom, number 5, the equity shareholders. Remember what we talked about earlier? They are the residual owners. In liquidation, it becomes crystal clear why equity shareholders are always the absolute last to eat. Usually, the plate is completely wiped clean by the time it reaches them. Which brings us to the end of our explainer, and I want to leave you with a very provocative question. Think about everything we've just covered today. Does the strict corporate veil of Salomon really still protect founders today? Or has the ruthless efficiency, that strict 330-day timeline, and the absolute power of the IBC made promoters more vulnerable now than ever before in history? I challenge you to really ponder these modern realities, master these legal concepts deeply, and understand the true heavyweight of the corporate life cycle. Thank you for your absolute focus today. Keep learning, and I'll see you in the next explainer.